question to our lawyer, and it specifically is, how sure are we that there are no other facts or circumstances they're sitting on as far as they could bring additional litigation for things that happened 10 years ago or 11 years ago?
Well, it's a very good question, and it's also got a pretty simple answer. First, the one that any lawyer will give you is anybody can sue anything by paying a filing fee, and it still be a completely invalid lawsuit. So that's the general way to answer that question. But to be specific to this case, and what the release does is, first, if you haven't seen the document, and it should be available to you on the town's website, and if you afterwards you can certainly read it. We've listed literally by case name and number every proceeding, all of them. We didn't leave anything out. And the way we referenced it in the document is we said, any of the facts and circumstances that are alleged in any of the proceedings over the past almost dozen years are covered by this release. Moreover, there's a bigger problem that is much more practical. All the events now that they complained of occurred no later than 2010, and the vast majority of them occurred before 2008, which means they're well past any statute of limitations.
Okay. In that case, I would say this cancer's gone on too long, and we just need to get it over and done with.
Good evening, Mayor, members of council. My name is Tony Galley, 4715 Dixie Drive. It's good to see you all. I was surprised when I heard about this offer, and it brought back a lot of memories. Some good, some not so good. But first and foremost, this wouldn't have happened without your own perseverance and endurance to make a decision to litigate the community. In 2008, 10 years ago, the rough aggregate value of property in Ponce Inlet was $1 billion. We since endured a real estate slide. We're back up, and I can only estimate it somewhere between $1.25 billion and $1.5 billion now. So you have to ask yourself, was it worth spending money to defend our land use code, our ordinances, our sense of who we are, our comp plan, to preserve that equity in the billion or $1.5 billion? Hell yes, absolutely. Did I like seeing it spent? Absolutely not. On one hand, it feels good to be vindicated. There's another part of me that feels like it's time to let it go, time to move on. I could sit here and justify going after the litigants, but I really believe it would be a case of spending dollars chasing nickels, with a lack of certainty about the ability to capture or recapture any of that money. So I think it's time to move on, time to heal. That's what I'm doing. Thanks for your time and for the opportunity to speak about this.
Thank you, Tony. May I say something that I should have said? No, Ms. Davis, please come to the podium. It won't take long. But I meant to say it in my presentation and I forgot, but I think you all should know this. The members of the council here will know, and past members of the council will know, and some of the members of the audience will know, but others of you may not. We spent $5.4 million in cost and fees, and no one is ever going to tell you that's a cheap date, even though it took place over almost a dozen years. But what you should also know is the lowest settlement proposal that we ever got, from Pacetta, was like 13 to 15 million plus approval of all the entitlements they wanted for the property. So we also fended off at one time a judgment in excess of 30 million, not including attorney's fees. So it's a big number, the 5.4, but it also has to have some perspective.
Barbara Davis, 4871 Steelfish Drive, and yes, I think it's definitely time to settle this and be finished with it. The only question that I had was Blue Water Realty Advisors LLC. What happened to them? And my only other thought would be that now that we have our ordinances established and we have defended them, we welcome whoever is going to build on that riverfront property, which is part of Ponce Inlet, because For years and years, we have been doing vignettes and charrettes and planning back to Stan Driscoll probably 25 years ago. And I think, you know, from that time on, our planners have really worked hard to craft the ROD, to craft our ordinances, all the fine tuning that you all have done. And it's time for that to be developed responsibly and beautifully. And I think we need to welcome whoever is going to develop that and not hold any grudges against anybody for this litigation. It's unfortunate it happened. It's time that it's over. And like Mr. Gowdy said, we just need to heal and move on.
Thank you, Barb. Go ahead. I'll answer your question. And again, this is almost one where only town insiders will know who Blue Water is. But let me explain. At one point, the judgment that I referenced that turned out to be $30 million, not including attorney fees, which would have pushed it closer to 40, was over 4 of the 10 parcels that were assembled to be developed as one. I won't avoid the parcel numbers, although people up here will know exactly which ones I'm talking about, but there were 4 of them. And those 4 had a mortgage, and those 4 had a mortgage from a bank called BB&T. Those also happened to be, I'm sure it was just a coincidence, be the ones that Judge Parsons found were taken from Pacetta. Just coincidentally, they were the only ones with a mortgage. But at any rate, BB&T, after we won the first appeal, continued foreclosure on those 4. And when he did so, it got a judgment for foreclosure on those properties and set the sale, which happens in a foreclosure. You set the sale of the judgment or the property to try to satisfy the judgment. And the judgment was in the millions of dollars. I can't remember, it was 13, 14, 15, but in the over $10 million number. I can look it up for anybody who's that interested. And they set the sale, and then they canceled it. And that was important to us at the time because we assumed if the property sells, then there's, at least for those 4 parcels, nothing more to fight about because the property's gone and it's not by our taking, it's by the banks. Sometime in December, and I think it was 2015, an entity called Blue Water bought the judgment. Now what that means in simple English is they didn't have the foreclosure sale and go to the sale and bid. They actually went to the bank and said, we'll pay what I assume to be a discounted rate to buy that judgment. Don't know how much that was, and most importantly, have no idea who Blue Water was. Not because we didn't try to find out. We tried to find out multiple times. But whoever is actually behind, I mean, you can look at the corporate records and you'll see the name of the lawyer, I think, who probably created it. But who's actually behind Blue Water is a mystery to this day. We don't know. But what we do know is that rather than do the normal thing that you would expect a judgment creditor to do, which is then set the foreclosure sale, and so they can ultimately become the owners of the property, that up to this day has never happened. And the reason that's important to answer Ms. Davis's question is because they are not in the chain of title even as we speak. We did an updated title search for all 10 properties in February, and when this started coming around, and I think it was February or maybe it was March, but recently. And they're all still controlled by Pacetta or Pacetta-controlled entities. And the way that works is Pacetta LLC owns all the stock of the other entities. So Pacetta owns the stock of Down the Hatch and Martim and so on. And Pacetta has property in its own name as well amongst those parcels. And so Blue Water is not a party to the settlement because they've never been a party to the litigation and they don't own any of the property, they only own the judgment. If they ever get the property itself and they come in, they would be like any other property owner and be able to apply. But they have no past claims, they have no current claims, we've never done anything to, with, or for Blue Water. There you go.
Joe, did you want to answer the question?
Just 2 things I just want to comment on. I want to reinforce Cliff's number of continuing this litigation and legal fees just by stating that Cliff is the pauper in this lawsuit. I think we only pay you, what, $190 or $195 an hour? Our attorneys on the federal case are getting $600 an hour, and I think Mr. Shirker, the attorney for the appeal, the state case is getting $800 an hour. Secondly, I don't think people really appreciate the importance of what has happened here, because if we had lost this lawsuit, it would have had statewide implications. A developer could go into a municipality and say, I want to build this. your zoning doesn't permit it. Change your zoning or I'll sue you under the Pacetta Ponce Inlet case. It may be as simple as that, just by proving highest and best use. I know, correct me if I'm wrong, but that's the way I look at it. And I just wanted to state that, so to clarify, maybe a little more understanding. Thanks.
Anyone else, please?
Roxenberg, 119 Beach Street. You know, it pains me to lose that money from the town over the years that we've had to do this. But I think another $750,000 is throwing good money after bad at this point, because I agree that trying to claim this in the end is going to be a tough deal. I think there's a lot of projects here in Ponce Inlet that money can go to start increasing, you know, our town's well-being, public safety, roadways, things like that. So at this point, I would agree that let's just lick our wounds, move on, and get past this. Thank you.
Thank you, Paul. Anyone else? No? Any further discussion from council?
Well, I would like to say a few things, if I may. The overwhelming majority of residents who reached out to me, and also what we heard this evening, at least those who spoke here about the settlement proposal, expressed their desire to see this matter brought to a conclusion and to move on. The Pacetta lawsuit represents perhaps the most expensive, time-consuming, and polarizing issue that our town has faced. Well, although the prospect of putting this matter behind us once and for all is very compelling, I know that there are residents in our town who would prefer to have us pursue the recovery of our legal costs. Those are the residents that I wish to briefly address in my comments today. The road to recovering the legal fees is a long and difficult one. We can think of each step as a link in a chain that has anywhere from 12 to 15 or perhaps more links in it. Everything would have to ultimately go right for us. Every lower court decision, every appeal, and the prospect of collecting on a judgment should we prevail. If this case has taught us anything, it is to expect the unexpected. Many of us who have been involved in litigating cases over the years have been left astounded by judicial rulings rendered in this case. A $30 million judgment was imposed, appealed, reversed, appealed, remanded, retried, and appealed again. Settlement offers finality. Rejecting the offer extends the uncertainty and risk we have lived with for far too long. There is no possibility that we could recover the entire amount, and accordingly, we can never be made whole. A partial recovery might be insufficient to pay for the costs we would bear in a pursuit which could likely result in several more years of litigation. We must not forget, as our attorney has pointed out, that there's a pending case in federal court where affirmative claims have been filed against the town, as well as an appeal pending in the 5th DCA. The agreement before us effectively ends these proceedings. There is no guarantee that we would prevail in either of these jurisdictions. The path to victory is too far from certain and not without significant future risk. I believe that based upon the circumstances of this matter, discussion with our attorney, conversations with residents, a review of the proposed settlement agreement, and my obligation as an elected official, it would not be prudent to undertake this risk. Accordingly, I have personally concluded that the odds of prevailing and recovering on a future judgment on balance are not worth the costs. And I strongly concur with Attorney Shepard's previous remarks. Even if we win, we may never collect on the judgment. The time has come to close this chapter in our history and focus on the bright and beautiful future of Ponce Inlet. Thank you, Mayor.
Can I add something? Sure. That's very well taken, and I think the proof of that is what happened the last time we were in the 5th District Court of Appeals, where they were supposedly would be ruling in our favor on the last point of Judge Parsons' initial ruling. And instead, they raised the question, well, maybe there's a partial taking on part of these parcels. Let's go back to square one and retry the whole case all over again to see, and these two words you may want to remember, ripeness and futility. If it could have been proven that Pacetta's had attempted to file an application for a zoning change, much less having actually filed one, we were in trouble. We would then have a court case to determine whether we were guilty, and if we were proven guilty, we would be back in a jury trial to award damages again. Now we're still in the 5th District Court of Appeals to appeal the court case that was heard by Judge France, which had to be held as a result of the 5th District Court of Appeals' last ruling. And fortunately, he ruled in our favor, but now that's back in the 5th District Court of Appeal. Do you want to gamble that they will rule in our favor? Which, even though we expect that, we may have some unexpected outcome from that. So I just want everyone to remind everyone who isn't aware of what happened the last time, that you just don't know what may come out of the courts. And I think, Cliff, you mentioned that with the federal case, since they're not paying their attorneys and the case can be, what is the word, with prejudice, without prejudice? You may want to explain that?
And this came into fruition, if you will, based on some other things which would typically be just kind of stuff between the lawyers that constitutes getting into the weeds. But since you've asked, I want to explain. About 2 months ago, maybe a little bit longer, one of the lawyers, the Gunster firm with Ms. Bulris, had moved to withdraw her representation in the federal case. At that time, both she and Mr. Huebner's firm were counsel of record in that case. The basic reasons given were that they weren't being paid. That obviously doesn't bode well for what's going on with the Pacetta folks. Really don't know the story, but I just know that's what was spelled out in the court papers. And we did not oppose, which is, we have an opportunity in federal court to oppose withdrawals, but we didn't oppose because we knew there would be at least one lawyer left, and that would be Mr. Huebner. The reason that's important is not all of the plaintiffs, as I mentioned, Mr. Johnson's a plaintiff in that case, but the other plaintiffs are corporations. And by law, corporations cannot be unrepresented in court proceedings. They have to have a lawyer. They don't get the option of representing themselves pro se as you or I would individually. They have to have a lawyer. And the significance of that is, in the absence of having a lawyer, the court on its own could dismiss their claims, but without prejudice, while they were given time to go get a lawyer, which means we could be sitting without a final resolution for some period of time before we ever got to the finality part of it. And in the meantime, maybe they would convince somebody to come in and take it over. Subsequent to that, I got a phone, maybe not within even a week, from Mr. Huebner saying, hey, I want to withdraw too, and for the same reason, I'm not being paid either. And so that's the conversation which caused him to understand that we were not going to agree to his getting out. And because we were not going to agree to him getting out, I think that forced the issue of where we are today.
And just to add that action of the 5th District Court the last time and remanding it back to the local court in the hearing that was heard by Judge France was unexpected, unbudgeted, and we had to take $500,000 out of our reserves to pay for the legal fees in that case. And the legal fees in that case weren't just to pay Cliff for defending us, because he had to defend that case with an appeal in mind. So the appeals attorneys had to be involved in whatever action Cliff was preparing in our defense. And that's how complicated, this has been up to now. Thank you.
Questions, comments?
Yes. I'm thinking back to the many years that this council has tried time and time again to put this to bed. There comes a time when you do what is for the greater good, and you don't look at the money. You look at what is good for your citizens and for your town. There was a time when I actually was appointed by council to try to negotiate the settlement. And I did that for a number of weeks. And that turned out to be time spent, but no gain made. And periodically after that, there was mediation, and there were groups of people that tried to formulate some way of putting an end to what was becoming actually a nightmare. Many of us have sat in court day after day after day, listening to hours of testimony, never knowing for sure where the judge was going to make his finding. But we had a belief in our attorneys. We knew that we had the right attorneys doing the right thing. And isn't that what we're all about? To do the right thing. And tonight, the right thing, in my opinion, is to say, we have been there, we have listened, we have heard what you want. I appreciate all of you that have been in contact with me and given me your opinion as to where we ought to go. And I haven't heard much negative response from anyone. I, for one, think that the time is now. Hopefully, you agree with that. Thank you.
The first trial in 2012 was 12 days long. And I remember on the 5th day of the trial, and I told Cliff this today, on the 5th day of the trial, my wife and I stopped by Town Hall to see Miss Witt. And she asked me how it's going. Because we were there, well, we were there all 12 days, but we were there the first 5. And I said, if Judge Parsons follows the law, we will win. It just took us 7 years to get there. And that's the shame. But it's time. It's time for it to be over. We did win.
Well, and I also was in all 12 days of that trial, and I happened to sit next to Cliff. And it was interesting, and as I heard everything that was there, it was kind of hard to believe that we did lose that trial. And I think part of it was the press. And if you people that have been here long enough and lived through all 12 years, every article in the newspaper and the magazines and even on the radio today, we're being vilified because we picked on a poor property owner. And nothing can be farther than the truth of that, because having been a developer, I never bought a piece of property that didn't have a contingency on it that I would get what zoning I needed or approvals I needed before I purchased the property. Pacetta went out and spent $20 million to assemble 10 pieces on a good guess that they might prevail. This town never changed the rule, and as Cliff said earlier, every rule that's in place today was in place 12 years ago. This town did not change anything. What they did was not approve many changes that Pacetta wanted in order to develop it the way they wanted, not the way we wanted it. And I hope everybody understands that the town has prevailed, and we have done and protected what we wanted, as somebody said earlier tonight. So, like the other members of this council, I think it's time to move on. So, you said it so eloquently. Would you like to make a motion?
Beforehand, in a personal note.
What?
A personal note. Because I came on this council in November of 2011. In 2012, while the settlement agreement was in our vault awaiting us to have a closed session meeting, I received a phone call from the Johnsons, did I want to visit the site? I have to say, when I came on this council, I was completely naive as to what was going on with regard to the lawsuit and anything that happened in the past, except the fact that they wanted to build a dry boat storage building down there, and the town didn't want it, and the town was divided over this. And I naively thought that this was a 20,000 square foot storage facility, not realizing that the 20,000 square feet had to do with just the one-story store buildings. I accepted, I spoke to our attorney said that I can speak to anyone I wanted to, and I accepted their invitation, and I'm sitting in the golf cart, touring the property, and we get to the corner of Beach Street and Front Street, and Mrs. Johnson points to the corner and she says, and that's where, I'm sorry, it was 10,000 square feet, 5 and 5 for the two. She points to the corner of Beach Street and Front Street and says, and that's where the dry boat storage facility is going. And I said, yeah, that's 10,000 square feet, isn't it? And she said, no, it's 60,000 square feet. Now remember that it was to be 3 stories in height, and I said, well, is that 20,000 square feet per level? And she said, no, that's footprint. And then I just said, footprint? And she said, and we won't take less than 45,000 square feet. And I'm trying to imagine, we live in a house in New Jersey that was on a 60 by 100 lot. And this building was to be 6 times the size of that lot. Our lots here are 100 by 100. So, I'm sorry, 10 times my lot up north, 6 times a normal lot down here, 3 stories in height, and the fact that she reinforced that it would look like a high-end luxury condominium. When I spoke to Mr. Jelani about that, our planning director, he indicated that there's nothing in the building code that specifies design. That even if that would be an enhancement, there was no way to enforce that. And it was at that point that I really understood what the problem was. Can you imagine having a 3-story storage building behind the homes that are on Sailfish Drive and Bounty Lane? And I just wanted to add that note. I got a lot of help for it. People thought I was negotiating with them in secret because I did announce it at the next council meeting that I had gone for this visit. But that was an eye-opening and a deciding factor for me in really understanding what was going on down there and why the public was upset over it.
I move to approve entering into the settlement agreement captioned, quote, full and final settlement and release agreement as to all claims, unquote, as proposed by the Pacetta parties and attached to the March 27, 2019 Town Council Agenda Special Meeting Item 5, and authorize the execution of the agreement on behalf of the town.
Second.
We have a motion and second. Let's have a roll call, please.
Councilmember Brisky.
Yes.
Vice Mayor Haas.
Yes.
Mayor Smith.
Yes.
Councilmember Perrone.
Yes.
Councilmember Milano.
Yes.
5-0 passes.
And with that, we'll take a short recess until we start the next item there. So we